Hello and welcome to Jaw Law. I'm your host, Joe McGregor from Dallas, Texas, and today we're talking about all the drama surrounding the FTC non-compete strike down.
Any material communicated on this podcast is for general informational purposes only and is not intended to be legal advice. Nothing herein should be considered to create an attorney-client relationship. Please consult an attorney for legal advice on your matter.
Okay, so before we get started, a couple of housekeeping items. Number one, thank you to those who have liked and shared and reviewed the podcast because it is so helpful, and would ask as a favor to you who listen and have not done that, if you could please help us out. It really does help get this out to more people. And not only to get out to more people, obviously the purpose here is to help as many dentists as we can. Next item up is a reminder that on January 17th, we're hosting a workshop here in our Dallas, Texas office. It's going to be from 9 to 1, and we're going to have a few professionals, industry experts, who are going to educate you and importantly, answer all your questions about either buying or starting a practice. Again, the promise here, this is not like a salesmanship thing where we're trying to get certain people in front of you so that you'll hire them. Instead, we're trying to just have a few hours of pure honesty, even if it cuts against people's interests, but to help you fully understand how to make these decisions, how to get financing, how to find a practice, how to find a location, maybe the pros and cons of doing a startup versus a practice purchase. It'll be a good time, but you need to register www.jawlaw.com. There's a form on that page. Find it, fill it out, and register. It's free, but the space is limited. We're capping attendance, so make sure you go do that. And now on to the show. And the show is pretty exciting as far as dental law goes. This is about as sexy and thrilling as it gets, which maybe is a little sad. But for those of you who have been following along at home, remember we've had 2 previous episodes so far. And those 2 episodes, first of all, talk about a rule that the Federal Trade Commission rolled out. In fact, we've actually done more than 2 episodes, but 2 recent episodes. I'm pointing them out because I don't want to have to rehash everything. But just suffice it to say that the FTC rolled out a rule banning virtually all non-competes. And again, a non-compete is this prohibition on an employee being able to work upon termination either nearby their former employer or some other restriction like that. But the way we most commonly see these are these mileage restrictions. So if you leave a practice and you can't practice 10 miles from that practice, once you leave, that's a non-compete. That was ruled as unenforceable earlier this year. And then we had an update a couple of weeks ago because there are a few challenges to this rule. The one we're talking about today is one in Texas. It has made, as of 2 days ago, it has made this rule that the FTC rolled out unenforceable. So it's suspended. It's not happening yet. The case, for you who are nerdy enough to go chase it down, it's Ryan LLC, which is this tax preparation firm. It's Ryan LLC versus the Federal Trade Commission. So they sued the Federal Trade Commission, and going back to a previous episode, what happened was the judge suspended the rule, the FTC rule, the non-compete rule, for Ryan. And what that means is that when someone files this injunction, which means, hey, we want this law to not go into effect, and because it was supposed to go into effect September 4th, and Ryan said, if you do that, we're going to be pretty screwed. So please don't let this rule go into effect. And the court at the time said, okay, we will not let it go into effect for you for now. And we're going to come back and we're going to make a full ruling in August. That has now been done, and the judge has issued that ruling. And importantly, we'll talk about this, but importantly, the judge made the ruling not just for Ryan, but for everyone nationwide. Now, I don't want this episode to get into the nitty-gritty because honestly, it's a little bit boring, but I think it's important to highlight some of this opinion so that you understand maybe what's the likelihood of this continuing, this kind of creeping back up, or if you're someone who is in favor of the FTC rule, what's the likelihood of getting it back on, right? And so, on this podcast, we don't take sides. Even if we have our personal opinions, we are trying to inform. We're not trying to choose sides here, just trying to educate. In summary, Ryan, the company, they had said that the FTC rule violated something called the Administrative Procedure Act. They pointed to a few reasons. Number one, the FTC lacked the authority to promulgate the rule in the first place. Number two, even if it did have that kind of authority, that we talked a little bit last time about this non-delegation doctrine, that even if they had the authority, this violated that non-delegation doctrine. Number three, it is unlawfully retroactive, right? So you have all these contracts that are in place, millions of contracts, and it's just throwing them aside. Number four, that the FTC was arbitrary and capricious. And we don't have to get too deep into that, but it's like, what does that mean? Well, it's in reference to that Administrative Procedure Act when it instructs a court, hey, if you ever see an administrative agency being arbitrary and capricious, you got to set aside whatever they're doing, whatever rule they made. And so that was another point of attack. And then finally, and we're not going to talk about it, but the FTC is unconstitutionally insulated from presidential control. And that's a quote, but we don't have to touch that. My vote around politics. And that ultimately wasn't what the court focused on. And just really briefly, maybe out of fairness, the FTC made an argument as well as to like why they could do this. And of course, they're citing the authority in the actual act that created the FTC in the first place. And I think it was like 1914 I was reading. And they're saying, hey, this is part of what we do, that they've been charged, and I'm quoting from that law, prohibits unfair or deceptive acts or practices in or affecting commerce. And interestingly, the judge agreed with that part, that she's not disagreeing with it. She said, hey, that doesn't mean you can make substantive rules that have these far-reaching effects. In fact, she pointed out that that rule doesn't like give penalties or any kind of sanctions or anything for violations of that. Quoted, it's housekeeping rules. That's what the authority is for. And so, therefore, without an express permission from Congress, that the FTC just can't make this kind of rule. In fact, one of the quotes from the case is, the role of an administrative agency is to do as told by Congress, not to do what the agency thinks it should do. So maybe a difference of opinion as to what role an administrative agency like the FTC should even play, especially when it comes to far-reaching rules that have a great ability to impact the American economy. And ultimately, the court focused on two arguments. Number one, that the FTC exceeded its statutory authority by making this rule. And number two, that the rule is arbitrary and capricious, which again, like I said earlier, means they have to set it aside. One thing that I thought was interesting is the judge said that this rule imposes a one-size-fits-all approach with no end date, which fails to establish a rational connection between the facts found and the choice made. Lack of evidence as to why they chose to impose such a sweeping prohibition that prohibits entering or enforcing virtually all non-competes instead of targeting specific harmful non-competes renders the rule arbitrary and capricious. Sorry for the extra heavy dose of law today, but it's important to kind of pick that out and try to understand what that's going to mean for future courts, because just right before this, a Pennsylvania court said, because this was contested in Pennsylvania, if we remember back from a previous episode, that Pennsylvania court actually upheld the FTC's ability to make this rule. So now we've got this difference of opinions. There was also recently a Florida court that struck this down, but interestingly only did it for that particular plaintiff. So keeping it case by case. So this is monumental because it has an effect on all employers. So this is directly targeting the FTC. And of course, the FTC is going to want to appeal, probably only going to want to appeal the Texas court case. And that's going to go to the Fifth Circuit. The Pennsylvania case, they won. So obviously they're not going to appeal that. But I'm expecting that the plaintiffs in that case are going to want to appeal. And when you have both appellate courts affirm these decisions, now you got a problem. You got a legal problem, and one that is spanning the entire country. So the chances that this goes to the Supreme Court is pretty good. You never know what cases they're going to take, but this seems like a pretty ripe one. And I brought up the legal aspects of this Texas court so that we can try to do our best to anticipate where this is going to go. And if you remember our last episode where we did also dive a little bit into the law, I think that my guess, and these are always just guesses, there's so many lawyers involved here and they all have different opinions. And there's a difference of opinion of whether this is, depending on what outcome you want, whether this is a good thing or a bad thing. If we're going strictly on the law, my guess, I'm inclined to believe that this is probably not going to work out for the FTC, particularly with the court that we have now, the Supreme Court. I just won't be surprised if what they say is, hey, FTC, you didn't have the ability to make that rule. If you really want that rule, you can go to Congress and Congress can authorize you to make that rule, or Congress can make the rule themselves. I think that's really what the American government wants out of their rulemaking process, and just wants the agencies to execute the law, not make the law. And so I think the court is going to encourage Congress, like, hey, if you really want this, if you want a national non-compete ban, go ahead and do that, but you have to do it at the congressional level. And then the FTC can enforce that, make its rules about how it's going to enforce it. But that's the way they want it to work. So I've never really had a lot of hope. And I'm not saying hope like as in I want it to happen or not happen. I'm saying I've never really expected that this rule would pass muster, pass legal muster. It was kind of damaged from the moment it left the garage. So what does that mean for you? It means, hey, right now, this rule doesn't exist. It hasn't like fully gone away yet. So keep an eye out, look for updates. But it had originally instructed employers to send out a letter to their employees who had a non-compete, advising them that you no longer have. Like, it just didn't want somebody thinking they had a non-compete, and in reality they didn't. And so you were under an obligation as an employer to send out these letters. Now you don't have to. And now, if you had a non-compete in place, we still have to honor it. Whether you're the employer or the employee, it is still, at least on its surface, honored. And if you want to challenge it, it's on a case-by-case basis based on state law, not federal law. I definitely don't think this saga is over. And by the way, like on a personal note, I know people on both sides of this. There are plenty of people who feel kind of hard done by certain non-competes. And there are plenty of practice owners who feel that stripping away a non-compete is going to be absolutely detrimental to their practice. I think at the heart of it, one of the attacks from the court was like, hey, you just, it's a light switch. One day you have non-competes and the next day you don't. There had to be some type of more thought put into this, whether you needed to affect all non-competes or just the really egregious ones. And did you need to phase it in, phase it out, something like that. And I think that's instructive for us. We have time for those who want a non-compete. There's no promise that they're going to be legal forever. So I think that now you have some time to think about if non-competes are ever fully done away with, what are you doing to protect yourself for that eventuality? And it's certainly no eventuality, right? But you should think about ways in which you can conduct your business and interface with your key employees just in case that happens. Bear in mind that there are states that prohibit non-competes and they manage. So this is an opportunity for everybody to kind of look over their shoulder and say, hey, what's everyone else doing? What should I be doing? How can I manage my business better so that this isn't as much of a threat? So like I said, this is not over. It will continue. So please keep updated. My cell phone number is 972-975-2215. Happy to answer any questions about this or obviously anything else dental related. My email address is jmcgregor@mcgregorfirm.com. Thank you so much for listening and for tuning in. It's really encouraging. It's fun to do this. And if you ever have any other questions, feel free to ask. And if you have any podcast questions, send those in. Shoot me an email. We'd love to answer your questions on the show. Thank you so much, and we'll see you next time.